Thank you very much, Adil. Okay, so first of all, thank you very much for inviting me to talk about introduction and fundamentals of arbitration. Thank you very much, this corpus, Ayush. Thank you very much, Aaron, for the introduction. So this is the first module of this course, and the first module is all about the introduction and fundamentals of arbitration. So before you get deeper into the field of arbitration, you get into choice of law, you get into setting aside foreign awards enforcement. The first thing you need to understand is what are the basics of arbitration. So in this session, what we are going to do is we are going to look at the basic framework of how do we resolve dispute and what are the different laws which are applicable in arbitration and what are the key terms that you need to know before you move into the next session. So let's start with the first part of the slide. Why do we actually talk so much about arbitration? Why is that arbitration is the buzzword? Because if you have to resolve disputes in India, there are two ways to resolve. One is the traditional methods of dispute resolution, which is more like you go to courts. So for example, let's say you buy something from Amazon and then you have an issue, you have a consumer forum. Consumer forum is more like a tribunal setup under the Consumer Protection Act, from where you can resolve the dispute. The other option under the Consumer Protection Act 2019 is that you can also try out mediation. But at the end of the day, when you go to Consumer Protection Act 2019, there is a consumer forum in which the judges have to be there, which are appointed by the state. It's not a private dispute resolution. So when you go to courts in India, there is a tendency of more than 4.4 crore cases. And the average time courts take to resolve commercial disputes in India is 626 days. Now the question is whether litigation should be the first choice for dispute resolution. Now let's understand this, that there are two companies. One company makes an exclusive sale of, let's say, iPhone 16 Pro Max in India. The other company wants to pre-book it, let's say 1 lakh models of iPhone 16 Pro Max. Now the sale happened and the cutoff date for delivery was lapsed already. And now you have to, get the delivery, but the delivery is not done. So you have to go somewhere to enforce the contract. One of the easiest options which will tell me that how you resolve this dispute is that you go to court and you file a case. But understand this, when you go to courts, can you choose the judge? The answer is no. Can you choose the applicable rules, the applicable law? Can you say that I don't want to apply the Indian Civil Procedure Code? I want to apply, let's say, CISG, right? Or let's say Singaporean contract law. The answer is no. The other thing is when you go to a court, there is a procedure which needs to be followed, right? And these things actually take a lot of time. Now, why is that in India it takes time? It's very debatable. There are so many reasons. But how do we actually see that it's actually a time-taking process? If you look at ease of doing business index ranking, in 2019, the last ranking, India's rank was 62nd. And in 2014, India's rank was 134th. But if you look at one of the parameters of ease of doing business index is enforcing contracts. Enforcing contracts basically comes down to dispute resolution. Let's say if one of the parties does not perform the contract, then you enforce the contract by forcing them to perform it. In that particular dispute resolution criterion, India's rank in 2019 was 163rd. Now, this showcases that how difficult it is in India to enforce contracts. If things go south and the contract is not performed by the party, and if you have to go to enforcing contract, which means either you go for some sort of dispute resolution, India's ranking in the whole world is 163rd, which is far behind than any of the developing countries which has a similar GDP. Okay. Now, because of all of this, the next best alternative to litigation is, of course, arbitration. Now, if we talk about arbitration, so this is what client thinks in litigation. The issue in litigation is that once you go to, let's say, a lower court in Sonipat, from the lower courts in Sonipat, then you make an appeal to either a longer bench or you go to the Punjab and Haryana High Court. From Punjab and Haryana High Court to Supreme Court, then of course you know that multiple benches, then there may be a chance of curative petition. Now, appeals are very wide in nature, which are not there in arbitration. In arbitration, the term used is called challenge. Now, challenge is pretty much limited. When I say challenge, it means that when I say the word challenge, it means precisely more aspects on the procedural issues, not the substantial issues. I'll give you an example for the procedural and substantial issues. Let's say that in the same example, the iPhone example, first is whether the arbitral tribunal has the jurisdiction to hear this dispute. Second is whether the contract has been breached by the respondent. Now, the first question is a procedural question, whether the arbitral tribunal has the jurisdiction, because that is something more related to the arbitration procedure. But if you look at the breach of the contract, whether B has to pay how much to A, that is all substantial. That's why we call CPC as a procedural law, and we call Contract Act as a substantial law. Okay, because when you have to look into whether A has breached the contract, you look into the contract law, and that actually helps you to decide who has breached the contract. But when we talk about the validity of arbitration agreement, it's a procedural part. Now, in a case of challenge, the procedural issues can be looked upon, but not the substantial issues. Okay, but in an appeal, you can of course look into the procedural as well as substantial issues. So, for example, you must have heard that the lower courts, the high courts have decided something, and the high court or the Supreme Court has said something exactly opposite of that, including, for example, let's say A has been jailed for 10 years by the High Court, and the Supreme Court says no jail and you are free to go. Okay. In that case, they're actually deciding on the substantial part also, whether they have committed a crime. They say there is no crime, so there is no jail. So this is the difference in between procedural and substantial issues and challenge and appeal. So in arbitration, we have challenge as a procedure, but there is no procedure for appeal from the arbitral award. Okay, now let's look at the background to the arbitration legislation in India. So currently, we have an act, which is 1996 Act, the Arbitration and Conciliation Act, which was based upon the UNCITRAL Model Law in International Commercial Arbitration 1985. Now, let's understand what is this UNCITRAL Model Law. You must have heard of there is something called Model Law on ICA arbitration. UNCITRAL is a United Nations subsidiary body, and their ultimate goal was to modernize and make uniform laws for the rest of the world. Now, UNCITRAL Model Law International Commercial Arbitration is more like a template law. Okay, just a second. So, UNCITRAL Model Law is a template law. For example, when you get a call and you get an option to cut and send a message, that is more like a template, isn't it? So, you don't have to type that I'll call you later. It's more like a template. You just tap on that. Similarly, you have a template for a national law. And the national law is the template for the national law on arbitration is UNCITRAL Model Law. So what India has done, India has adopted this 1985 UNCITRAL Model Law. So if you look at the UNCITRAL Model Law and the 1996 Act, you'll find a lot of similarity because India has adopted it. It's not only Indian law, which has been drafted after adopting UNCITRAL Model Law. Singapore, Hong Kong, all of these countries, Malaysia, have actually adopted the UNCITRAL Model Law 1985. So basically, the Indian law was drafted after adopting this. So it's more or less pretty much similar. However, UNCITRAL Model Law also has an amendment, which is in 2006. But if you talk about the Indian Arbitration Act, you have seen the amendments coming afterwards, and currently there is another amendment, 2024 bill, which is a draft bill which has been open for public consultation, where different changes has been proposed. For example, inclusion of emergency arbitration. Now, in the Arbitration Act of India, there are two parts. So technically there are four parts, but for this session we are going to discuss the first two parts. The first part is domestic arbitration. Second is foreign arbitration. Third is conciliation. And fourth is a miscellaneous part. Sorry. So the first part basically provides that this first part is applicable to arbitrations which are seated in India. Now let's understand what do we mean by arbitration seated in India. So understand this. Arbitration is very international. Let's say that there are two parties right here from this session, and you two have a dispute, and you want to do an arbitration in Singapore. Okay. Now the question is, are you allowed to take the dispute outside India in an arbitration? The answer is yes, you can. So let's say two Indian parties decide to have an arbitration in Singapore, which means that the Singapore Arbitration Act will be applicable. To understand seat, let's understand this with this example. So I see two of you, Hussain and Unnati, on the session. So let's say Hussain is one party, Unnati is another party. You two have a contract with respect to sale of iPhone 16. Okay. Now you guys decide that if in case we have a dispute, we'll not go for arbitration, we'll not go for litigation, and we'll go for arbitration in Singapore. And you say seat will be Singapore. What do we mean by seat will be Singapore? It means that the national arbitration law of Singapore will be applicable to our arbitration. Which means when we say that seat is Singapore, seat is New Delhi, what's the difference? I'll give you an example. When you say seat is New Delhi, it means that let's say if there is anything for the arbitration, any supervisory role which has to be performed, it will be only the Delhi courts. For example, appointment of arbitrator. If Hussain and Unnati have to decide it for one arbitrator, both of them, Hussain says that I want to appoint Aryan, Unnati says that I want to appoint Akash, and you can only appoint one arbitrator. So what do? You have to go to the courts in Delhi. Why in Delhi? Because the seat is Delhi. Okay. If the seat is Singapore, who gets to decide all of this? It's the Singaporean court, not any other court, right? So this is what we mean by seat. Now the next thing, and seat is always a city. It's never a country. Why? Anyone? Why do we say that seat has to be a city and it can never be a country? Yes, Ritu.
Because only Supreme Court will only appoint an arbitrator in case of international matters and not the otherwise around. Other than that, state are responsible for appointing the arbitrators if the parties want to have an arbitrator. So they have
Okay.
the
So what
liberty to
if
either. Yes,
so
sir.
what if I say that in Unnati versus Hussain, they say India is the seat. Which courts will get to appoint the arbitrator?
If it is an international matter wherein Singapore and
It's not an
India.
international matter. Unnati and Hussain are all situated in India. They don't have any business outside India. So it's not international commercial arbitration.
So I think so that there will be a mistake in this matter, particularly because the lower
Mhm.
authority is the High Court, and then you move to the
Hmm.
Supreme Court. Supreme Court will enter only when there is an international matter, and High Court is not.
Exactly, which is not the question. I didn't ask if it's an international commercial arbitration. I just asked you a very simple question. Unnati and Hussain have drafted a clause that India is the seat. Both of them are purely Indian. They don't have any company outside India. They have no relations outside India. All their assets, all the companies is in India. Now, who will appoint the arbitrator? Which courts will you go to?
Uh, I'm sorry, but I don't.
Okay. What if instead of India, they have used the term New Delhi as the seat? Which courts will you go?
Uh, the High Court, Delhi High Court.
Now, guys, please understand this. When you say India as the seat, India is huge. Which city, right? Which city is the court? Which state, right? So you need to always mention a city. When you say Sonipat, when you say New Delhi, you get the jurisdiction. But when you say India as a seat, it becomes a problem. So this is what we mean by seat. And The seat law is also called lex arbitrae, which is the national arbitration law. Now, what do we mean by venue? Anyone? Are seat and venue the same in arbitration?
They are different.
For example,
Uh, just a minute.
if I say that they have chosen Singapore as the seat, however, the hearings will happen in Miami, US, which law will be applicable? The US law, Miami law, or the Singaporean law?
It means that the laws will be applicable of the New Delhi, and the place of venue means both the parties.
The seat is Singapore. The seat is not New Delhi.
Okay. If the seat is Singapore,
Hmm.
so the laws will be applicable of the Singapore and
Okay.
whichever particular city, and the venue will be Miami. It means that
Hmm.
the whole process, the sitting,
Hmm.
and all the discussions of arbitration will be held in
Hmm.
Miami.
So Miami laws will be applicable or not?
No, it will not be applicable because they are just
Exactly.
sitting over a particular place.
Exactly. So, for example, a very classic example is the seat is Singapore. This Zoom call is where we do the hearing. Does Zoom has a national arbitration law? No, right? So that's the meaning of venue. Venue has no relation with the arbitration. It's just a place where you actually meet and discuss and you do the hearing. So you choose Miami for that, you choose Zoom call, it's not going to affect. Okay. But seat is very important because the seat law will be applicable. Any questions so far? Okay. So let's go to the next part. So first, what's the process of an arbitration? It's pretty much like this, that first there is a notice for invoking arbitration. Let's say that you have a dispute. You send a notice to the other side. The other so the other side replies to the notice. Then the first stage is the appointment of arbitrator. Sometimes that also becomes an issue because one party says that I want to appoint X, the other party says that I want to appoint Y. Then you don't know which one has to be appointed. Then you go to court under Section 11. Yes, Ritu, you have a question.
So what in the situation wherein arbitration clause can be added in the contract while making it or after the contract has been made? That's how arbitration goes. There is not compulsion that the contract should have the arbitration clause beforehand. So what in the case uh, the situation has held wherein the arbitration is needed?
Hmm.
And for example, the situation wherein you took off iPhone 16 Pro, whatever. So my question is, when the arbitration clause is added afterwards, in that situation, which particular seat is applicable, how we will know?
Okay. So first of all, whether it's an arbitration clause and arbitration agreement, whether it has been inserted before the dispute arose or afterwards, it doesn't matter. Both of them remains the same. It's not me saying this. It's Redfern Hunter in his book. He argues this that it's just the nomenclature and the timing of arbitration clause. Second, the question of seat. Okay, that what is seat? What will be the seat if the parties do not mention it? Then it
Yes.
becomes a pathological clause. A pathological clause is a defective clause. Okay, a defective clause is, for example, there is no mention of seat. So which courts do you go for appointment of arbitrator? You don't exactly know, right? So sometimes these have to be cured by the courts. But there are two sets of arbitration. One kind of arbitration is ad hoc arbitration. You must have heard this in India that two contractual parties have a dispute. They decide we'll have arbitration. They appoint some very senior professionals within legal system, and then they have their arbitration. But some of them you must have heard that it's called Mumbai Center for International Arbitration or IMC Hyderabad. So there is an institution which actually helps you. So if you have an institutional rules mentioned within it, then it's very easy because all the arbitration rules provide that if you don't mention a seat, ICC says that it's Paris, IAMC says it's Hyderabad, MCIA says it's Mumbai. So if it's not an institutional arbitration, then you have to go to a court to get some help, or either you guys have to settle and finalize a seat. but that's a pathological clause, which means that will become a dispute in itself, that what will be the seat. Okay. But that is a curable defect. Yes, Krishna, you have a question.
Yes, sir. Building upon the last question, I guess the question was, suppose there's a contract between two parties and the contract does not have any arbitration clause. And in that execution of the contracts between the parties, there's a disagreement or some dispute. So can the both parties, because if the like or say there's a breach of contract and both of or suppose one of the party has to deliver something and he's not delivering, so contract has been breached or say it's dead now. So can afterwards they both of the parties bona fide choose कि, okay, now let's go to arbitration, or they will have to go to the consumer court like that. So can
No, no.
arbitration
So
agreement be included afterwards the contract has been finalized
so
as well?
if both the parties do not have an arbitration clause in the main contract, after the dispute has arisen and both the parties are ready to sign up to an arbitration clause, they have all the rights to do that.
All
There is
right,
no
sir.
problem with that. Yes. And technically, the only difference in between arbitration clause and arbitration agreement is this. Understand this. When, let's say, you write a contract, you enter into a contract with Ritu, and in the sales contract itself, you have one of the part, which is arbitration. That's technically called an arbitration clause. Why clause? Because it's a part of the main contract. Okay. And what is the meaning of arbitration agreement? Let's say you and Ritu have a dispute. There was no mention of arbitration. 10 days later of the dispute, you guys realize that it's not very good option to go to courts. You guys signed to another agreement, which is called one arbitration, that is called arbitration agreement. That's the technical difference in between an arbitration clause and an arbitration agreement. But if you ask me, is there any difference in terms of effect, validity, legality? The answer is no. Both of them are good as each other. It's just the timing based on which it's called arbitration clause and arbitration agreement. However, within the international arena, we use both of these terms interchangeably. So there is no problem with that. But the technical difference is this, what you and Ritu pointed out. Okay. Okay, now let's go to.
I'm
Sorry, somebody has
sorry
a
to
question.
interfere.
Yes.
One more question. Last question for sure.
No, please feel
Regarding
free to ask. The idea is that you guys ask questions and we have a conversation. Yes.
yes, sir. So, arbitration clause and arbitration agreement both are signed by both the parties. While
Yeah.
and for example, an arbitration is accepted by both the parties, wherein a mail was sent by either of the party. Like the party A sent a mail to the other party that I want to enter into an arbitration clause. So, by not responding, does it mean that they have both accepted by not responding to it? Because
Okay.
this is
So
yes. Sir.
I understood your question. So there are so many cases in India and also outside India with respect to what constitutes arbitration agreement. So let's say if there are cases, so your question is actually one of the cases in which A sends to B that we should do arbitration, we should include arbitration in our clause. The other party never replied, but the other party was replying to all the other emails. And that's something what we call a deemed acceptance of this offer because you had access to it. And when it was a part of the contract, you signed the contract, but you said, I was never aware of this. So technically, if there is consensus ad idem of the parties to do arbitration to resolve all their disputes, that's the test which we look at for the validity of an arbitration agreement. It doesn't matter whether it's paper, whether it's email, whether it's WhatsApp. If there is some form of record which you can showcase that the parties had the meeting of minds, that's the ultimate test, which we also derive from the contract. So that's the same for the arbitration agreement, just that the parties have to be on the same side with the consent. That's it. So
Thank you,
first
sir.
is notice, second is appointment. Third is with respect to how you conduct the proceedings, you have to make sure that you give equal treatment to the parties, commencement of arbitration proceedings, and then the hearings. So interim reliefs are also something which the parties can seek. Oral hearings and written proceedings. After the hearings, then there is an arbitral award if The award debtor is the losing party, award creditor is the winning party. The award debtor has a right to go and challenge the award within 30 days from the date of receipt of the award, then execution of the award, and then if there is any appeals which you want to take it further. Now, this is another picture which indicates why is that 90% of the Indian companies sign up for arbitration. So this picture is actually an indication that companies don't want to do litigation because of a very simple reason, because of different sort of appeals. And it takes a lot of time to resolve it. I'm not saying that once you do an arbitration, it's ultimate. The moment you have an arbitration award, the party pays the money at the end of discussion. It's just that if you compare the pros and cons, arbitration will have somewhat more edge because it's more regulated and it has less intervention from the court. Okay. Now let's look at the history of arbitration in India. The first law, which was Indian Arbitration Act 1899, came and it was only applicable in the presidency towns, Calcutta, Madras, and Bombay. Then 1908 CPC came in. 1940 was the English Arbitration Act. But the English Arbitration Act, the 1940 Act, only had domestic arbitration and not the foreign arbitration. What do we mean by domestic arbitration and foreign arbitration? Let's say if we say that the seat is Sonipat. This means that the national arbitration law will be applicable. The national arbitration law in India is Arbitration and Conciliation Act. If I say that the seat is Singapore, which law is going to be applicable? It's the Singaporean Arbitration Act, right? So when I say that the seat is India, it's a domestic arbitration. When I say that the seat is non-Indian, outside India, that's foreign arbitration. The part 1 of the Indian Act, the current Indian Act, has 4 parts. The first one is domestic, which means if the seat is in India, that part applies. Part 2 is foreign arbitration, which is applicable only when the seat is outside India. But in 1940, there was no division. It was just domestic arbitration. Foreign arbitration were not taken into consideration. Now, what was the exact reason that India didn't have foreign part in 1940 and 1996 we had it? The difference was because India is a signatory to the New York Convention in 1958. To give effect to New York Convention, India came up with a part 2, which is foreign award enforcement. Now, what do we mean by New York Convention 1958? Understand this. If let's say you have an award in Singapore, in the same example, Unnati and Hussain, they had an arbitration. Let's say Unnati has to pay 10 million to Hussain. The award is rendered in Singapore. How does Hussain enforces this in India? Because the arbitration never happened in India. It's an Singaporean arbitral award. So how do you take that award, come to India and enforce it? Anyone? Can you enforce a foreign award? Any award coming from outside India? Yes, Unnati?
According to the guidelines.
I'm so sorry, your voice is very low. Can you be a bit louder? We can't hear you actually. Okay. So if you have to enforce a foreign award, you need to get certain international law which provides that you can take award from one country and enforce it in another. Now, New York Convention provided that any member country award can be taken to another member country and that has to be enforceable, which India is a signatory. 170 plus countries are a signatory to it. Now, to include that within the Indian law, we came up with 1996 Act. Also, we had adopted 1985 Ancestral Model Law. So what we have done, we have actually inserted that within the 1996 Act. So after that, there were multiple amendments starting from 2015, 20 1917 and then in 2024. So there have been multiple amendments. Okay, now let's go to the next discussion of subject matter of arbitration. Do you think all the subject matters are suitable for arbitration? For example, live-in relationships. Uttarakhand was one of the first states to regulate live-in relationships in India. Now, do you think if two people who are having a live-in relationship, they have a dispute, can you resolve that through arbitration? What do you think? Yes, Ritu.
I personally think it cannot be resolved due to its
Hmm.
nature. As in, the arbitrators, particularly, they are not the judges in there. Maybe they are the judges, maybe they are the retired judges, maybe they are the senior advocates sitting. Maybe they are the new law graduates compelling various types of other educations plus to them. But since they do not qualify,
Yes.
I don't think so. They cannot particularly proceed with this particular matter.
Okay. So why do you say that these disputes are not suitable for arbitration? So let's ask, yes, Sushma.
Yeah, sir, I guess primarily arbitration is meant for commercial disputes, and
Okay.
these are like non-commercial matters, so arbitration
So
is
you
not
are saying
applicable.
that if it's not a commercial matter, you can't do arbitration.
Primarily, sir, yeah.
So for torts, you can't do arbitration.
Yeah, under torts it can be done, but yeah, if like basically the cases which pertain to social or like larger public order or like, social responsibility, that cannot be
Hmm.
arbitrable, I guess.
But okay, is that something which the Arbitration Act provides? Yes, Sushma.
Yeah.
Yes.
The conflicts which is related between the personal rights
Hmm?
and personal laws, it strictly prohibited from the arbitration proceedings, as of I know.
Okay. Guys, please understand this. Not all the disputes are suitable for ADR and arbitration. ADR suitability is one, arbitration suitability is another. I'll give you an example. If I ask the same live-in relationship, marital disputes, whether it's suitable for ADR, the answer is yes. Why? Because they have mediation also, ADR, right? You can mediate those disputes. For example, if you look at the sexual harassment rules in your educational institutions, one of the provision is that the victim can actually meet the offender in the presence of the committee members. What is that? That is actually a sort of mediation. But understand this, when I talk about the suitability of arbitration for sexual harassment or when of marital disputes or live-in relationship disputes, the answer is no. Now, how do we get to decide this? The Arbitration Act is silent on this. However, there are two landmark judgments which you should be aware of. One is Booz Allen and the other one is Vidya Drolia. Now, both of them have a very similar reasoning. So Booz Allen say that rights in rem, rights against the whole world. For example, when somebody does a crime, it's a right against the whole world that nobody should do a crime against me, right? That is something what we mean by rights in rem. You have a right against the whole world. For example, you have a property. Nobody should disturb your property. You have a right against the whole world, right? So this is something which is not suitable for arbitration. Rights in personam. For example, you have a contract. Hussain has a contract with Unnati. So who has the right to sue Hussain? It's only Unnati. I can't sue Hussain just because I think that Hussain has done something because it comes from a contractual dispute. So not all the disputes are suitable for arbitration. You have to understand this. And sometimes it also becomes a question of public policy. For example, let's say there is a country which actually allows, relationship disputes to be referred to arbitration. But India does not allow it. Why? Because India will say that this is against our Indian public policy. So this is another thing. Okay. Now let's go to the next part, which is jurisdiction of the arbitrator. Why jurisdiction of the arbitrator is important? Let's say that you have an arbitration agreement and one party challenges the arbitration agreement validity itself, that I never gave you the consent. What should happen? The arbitrator has to decide first on whether the arbitration agreement was valid or not. That is called competence. They have the competency to deal with that. The second concept is doctrine of separability. What do we mean by separability? It's this. When one of the party attacks the validity of the contract, it does not mean it's a direct attack also on the arbitration agreement. Why? Understand this. In the same example, Unnati versus Hussain, Unnati argues that the contract is invalid and therefore the arbitration agreement is also invalid. If, let's say, this argument is accepted, everyone who has been sued in arbitration, they will say that the arbitration agreement is invalid because the contract is invalid. So what happens when you challenge the validity of the contract? The arbitration agreement becomes separable in nature, and that becomes a separate investigation. I'm not saying that you can't challenge the validity of the arbitration agreement. You can challenge it, but that is not an automatic challenge when you challenge the validity of the contract. So this legal fiction is created to safeguard the arbitration agreement for the time being, so that the arbitrators can decide on the validity of the arbitration agreement. Now, this jurisdiction of the arbitrator, competence, doctrine of separability is something which you'll find under section 16 of the Act. Okay. And the previous one, subject matter of arbitration, is the subject matter of arbitration. If the subject matter is not suitable for arbitration, you can challenge the award under section 34. So let's say even if you have an arbitration award out of sexual harassment or let's say marital dispute, when you go to courts and challenge it, the courts will accept it and the courts will say that this subject matter is not suitable for arbitration. If let's say one of the arbitrator is biased, has certain personal relationships with one of the parties, in that case, you can also challenge the arbitrator under section 13. There are limited grounds for that. Okay. Conduct of arbitration proceedings, both the parties should get nearly equal opportunity of being heard. It doesn't mean that one party gets 60 minutes, the other party should also get exact 60 minutes, but it has to be comparable in nature. If this is not done, this also becomes a potential threat for the validity of the arbitral award. Form and content of awards, the arbitrators are required to set out the reasons. If the reasons are not provided within the arbitral award, then that award can be challenged. The second last point is setting aside of awards. So this is what we call challenge, annulment. It's all the same. Setting aside, challenge, annulment. So section 34 of the Act provides the award can be set aside if the party was under incapacity, the arbitration agreement was invalid, there was no proper notice, the award deals with a dispute which is not even contemplated within the contract, the composition of arbitral tribunal was not in accordance with the contract, subject matter of the dispute is not capable of settlement by arbitration. That's F. And the G is the arbitral award is in conflict with the public policy of India. There is also another ground of patent legality which has been added after the amendment, but that only applies to non-international commercial arbitration. Okay. So this was part one. The part two actually provides for enforcement of foreign arbitral awards. Let's say that you have an arbitration in Singapore and you have to enforce that in India, you need part two applicability, that is section 48. Section 48 provides that the Indian courts have a right to enforce or not enforce based on certain grounds, and the grounds are pretty much similar to section 34. New York Convention is the reason why we have part two, and India has signed up to this reservation, which means unless until the countries have a reciprocal arrangement. So let's say Dubai enforces our arbitration awards, only then we enforce their arbitration awards. So India notifies the reciprocal countries. Under CPC, there is a list of reciprocal countries. India only follows New York Convention with those set of countries. Reciprocal. Why? Because India has signed up to the reservation under Article 1 of the New York Convention. Okay, so this is you guys. When I ask you a tough question, some of you start losing your mic. Some of you are not even answering the question. So this is what I wanted to discuss. And now I open the floor for questions. We still have almost like 10 minutes left. So why don't you start asking questions? But also if I miss replying to your questions. My QR code is right here. Please feel free to ask me your queries later if we are not able to have a conversation here, but please feel free to connect. Yes, somebody has a question? Yes, Retu, please.
So my question is regarding the reciprocal thing that you have just said right now. For example, the Advocate Act, 1961, that particularly state about who can register in in India as an advocate. So it states that if a foreign advocate who wants to register, their country should also recognize us. If they can register ourselves there as an advocate, then only we will also recognize them. That's the Advocate Act, what it says. So similarly, in this particular situation, as an arbitration particular, whether it's applicable or not. So does that mean, for example, any country, I don't know the name, I'm just, it is just an hypothetical question. A country do follow the laws of New York conventions, but it doesn't consider India or take India in that manner. So will their law particularly applicable in India? For example, the country is Egypt.
Hmm.
They follow the New York Convention. It's just an example. They do follow the New York
No.
Convention.
So
Yes.
I understood your question. Your question is, let's say there is a country, let's say Singapore, and you have an arbitration in Singapore, whether that is going to be enforceable in India. And the other example is the arbitration is happening in India, the arbitration is seated in India, and how will that be enforceable in Singapore?
Yes.
So India has signed up to this reservation, which is like this. If Singapore is accepting our awards and enforcing it like their own awards, only then India will enforce the same, which a simple example is India signs up to reciprocal arrangements. For example, with UAE, with Singapore. There are, I think, 44 plus countries which India has signed up to this. And in the Gazette of India, they notify these countries. So even a judgment coming from a court in India, that will be enforceable in that country. And similarly, Singapore will have to enforce our judgments. And India will enforce Singaporean judgments. So India has used this reservation also for arbitration. So which means if let's say there is a country like Sierra Leone, one of the South African countries, if India has not notified that country and you have an arbitration award in Sierra Leone, you can't take that to India and enforce it. Why? Because India will say that not through the New York Convention route. Then you have to follow the longer route, which is there in CPC for foreign awards enforcement coming from a country which is not notified, which is a very long route. But if you come from a country which is notified country, then it's very easy. You directly file Section 48 because it's a New York Convention reciprocating country.
So is there any international law wherein if they do not have, if the party is from such a country wherein the New York Convention is not applicable or somehow
No, New York Convention is universal
it's
in nature
applicable? Yes.
because it's 170 plus countries. So almost 200 countries we have. So almost every country is a party to it. The problem is not whether people are party of NYC. The question is why India has this reservation. It's India's problem. It's not New York Convention's problem. Because India has signed up to this reservation that we'll only apply New York Convention when it's a reciprocal country. The international law is already there. It's one of the most successful international law actually. 170 plus countries, almost like a universal application.
Yes.
Yes.
Thanks.
Any other question? Yes, Susan.
So what if in an arbitration, if one party is like not satisfied with the the final decision of the arbitrator, so where can they appeal and what would be the process be?
So let's say that in your case, you versus Unnati, the award goes against you. You are not happy with this. What you can do, you can use Section 34 to make a challenge before the court. But the challenge is only limited to these grounds. I'll just go to that slide. Only these grounds. For example, biasness of arbitrator, arbitration agreement, invalidity, all of this. But apart from this, can you make any other excuse? The answer is no. Now, do you understand why arbitration has a very limited scope of intervention? Because in a normal case, you versus Unnati, when it's not arbitration, it's 100 grounds which you can take, right? But in this, it's a very specific grounds which is mentioned under Section 34. Apart from that, you can't go to court. If you go to courts and say something apart from these grounds, the courts will not even admit your petition. So Section
Got it.
34 provides the answer. Yes.
Thank you, sir.
Thank you. Any other questions?
So, is there a necessity that the arbitrator should have a particular uh, expertise in particular subject to be an arbitrator for a particular subject matter
Not
or so?
really. Not really. The Indian law does not provide for that. None of the other laws provide. It's just that you have to be a professional in India. For example, engineer, doctor, lawyer, anything, CA, CFA. It's just that you need to have a professional degree, nothing beyond that. You don't need to have, a lawyer experience, because if you go to the list of arbitrators, you'll also find that there are people who are CA, there are people who are, you know, engineers. So they're appointed in construction arbitration. So there is no mandate to be a lawyer. However, the majority of them, that it's lawyers, but that's not the mandatory portion. Yeah.
So what I know, there is no particular as a mandate or a requirement for being an arbitrator. So will that give a disadvantage to the lawyer community, as in, because if we are thinking to be an arbitrator, we
The
need to be
lawyers are
very
the lawyers
specific.
are the lawyers are already at a disadvantage, because not a lot of times you see lawyers getting the appointment. It's the retired judges who gets the appointment. So talking about disadvantage, if you compare it with people who are not lawyers, that's a very
Low
distant argument.
percentage.
Exactly, that's very low percentage. The actual argument, if you go to some of the arbitration conferences, you'll see this topic, that lawyers appointment versus retired judges appointment. So that's the majority portion. If you look at the total number of arbitration appointments, it's going to be very low with non-lawyer arbitrators. Just to give you an insight, MCIA chairperson has written on LinkedIn that out of, let's say, 100% of the cases of ICC, which is the biggest arbitration center, it's, I think, 1, 2, or 3% total in numbers, the Indian arbitrators get appointment. A similar survey needs to be done on how many lawyers get appointed as an arbitrator. And then you'll realize that it's a huge number of non-lawyers. When I say non-lawyers, of course, it means, different set of retired judges, right? So that's the actual question apart from this, because it's not a lot of times you'll see non-lawyers being appointed. Just to, give you a specific answer, if you go to, let's say, SEC Online or Manu Patra, you go to Section 11. Let's say only in August, Delhi High Court. Find me how many non-lawyers have been appointed. One of my students is researching on this. None. But if you ask how many females, how many non-lawyers, then it's a very low number, right? So that's the actual question, not exactly non-lawyers like engineers versus lawyers. It's the other side. So if you talk about non-male, you'll find very less number of female or LGBTQIA plus being appointed. So that's the actual question.
So my next question is regarding the career-wise. May I? Because I know topic is not regarding that. Regarding if a non-lawyer if a student particularly is thinking to take arbitration as their career, further career. So we do know, according to the brief, that what you have qualified and what was your process. But regarding for the career particularly, what a law student should do to become an arbitrator, particularly, wherein the competition is so tough. Like everywhere it's tough, but particularly in this particular field of law.
So there are so many things which you can do actually. So one is, of course, that you need to do good in your day-to-day curriculum, which is your courses in the law school. The other is that you have to start researching on these topics. So when I say research, everyone will say that I'm also researching. Research is not a quantifiable word, right? So how do you quantify it? How do you make it more like a deliverable? It's more like a publication. You write at good journals, you write in good blogs. Another opportunity which you can explore is something on arbitration moods or arbitration competitions. Another thing which you can do is more like a summer school or a winter school. The best summer school on arbitration is Paris Arbitration Academy, which also provides a scholarship for students. I have also got one from them. Apart from these, what you can do is, of course, you need to follow up with arbitration. So the easiest way to follow arbitration is that you use Kluwer Arbitration, the database, and the Kluwer Arbitration blog. Kluwer Arbitration blog is free. Like you can go to Google, write Kluwer Arbitration blog, different set of people write from different parts of the globe. So these should be the stepping stone. And for me, it worked because it was the WIS moot. WIS moot is more like an Olympics of arbitration moot. So where 400 teams participate in Vienna. So I did it thrice, and that's something actually helped me a lot to learn. But I never say that you need to do moots, arbitration moots to learn this. There are so many different ways of doing it. Either a course like this or a summer school or winter school. Every time I say that summer schools are better because they are more longer in version. Like they are like 3 weeks and stuff. So you should take electives in your law school. You should study arbitration in your law school, then moots, ADR competitions, writing papers, researching with this, or let's say research with a professor who is actually good in arbitration. You become an intern or research assistant. There are so many things. But let's say even after this, because I know that we are running a bit short on time, even after this, if you have some specific questions, so I'll be happy to answer your questions. I have already shared my contact details, but these should be the stepping stone. And it's just that you have to try all of these to know which one you are good at. Because unless until you try, you don't know where you are good at. Okay. Any other questions? So we have almost like 2 minutes. So if you have any questions, please feel free to ask.
Sir, I believe the participants have all the queries answered. And as the participants might be aware, sir has shared their contact details in the chat box. So if someone wants to reach out to them, they can do so. And in the end, I would like to thank we would like to thank sir and extend our heartfelt gratitude to Akash sir for accepting our invitation and delivering such an informative session. We trust that the audience found it both interesting and knowledgeable. So thank you once again, sir, and we eagerly anticipate the opportunity to host you again.
Thank you.
Thank you, sir.
Thank you, sir.
Thank
Thank you
you.
very much.
Thank you.
Thank you so much.
Thank you, sir.